Okay, so let's see what this order is. Only 6 pages. The protected order in this matter was put into place to protect sensitive information. Ah, we know what this one is. Okay. So, I think it was mostly, I don't know if it was on both sides, but I know Elaine did not want certain documents to be unsealed. However, Judge Penney, during the June 24 post motion trial, I still called a trial, post motion court meeting, was like, the trial's over and everything's gonna be unsealed. And especially if you're gonna go to appeals, everything should definitely be unsealed and it should be public, available for the public. And so Elaine was like, "Oh, that's not what I thought. I thought we were gonna keep things unsealed." So now the judge is like, "Nah, we're gonna unseal everything because it's let's see what she says. In this matter, well, the protective order in this matter was put into place to protect sensitive information and to ensure an untainted jury. In this matter, both litigants sued one another, thereby opening themselves up to the public forum of a jury trial. Court records are public information. The case is now concluded, and therefore the court carefully reviewed all the documents that were filed unsealed. It is appearing to the court that certain filings in this matter should be unsealed. It is therefore ordered the following documents to be unsealed." I'll read these documents, but we're not going to know what most of this means. Maybe I won't read it. Let me see. Let's just skim through it. Let's see if anything pops out of my, let's see. Expert witnesses, something about independent medical examination. Oh, man. I don't know. I feel like without looking at the documents, we don't really know. I mean, I wouldn't know what the hell it is. But, oh, cloud backups. So I wonder when it becomes unsealed, will it appear on here, or is that like a separate area? Oh man. Because it would be very interesting to just kind of just take a peek and see what's going on in here. All right, yeah, it's just a bunch of stuff here that's going to be unsealed, and that is Judge Penney Azcarate's signature. All right, we have a next document over here. What's going on? Order. This cause came before the court upon defendant Laura Amber Heard's post-trial motions. After review of defendant's post-trial motions, plaintiff's opposition, and the relevant statutes and case law, it is therefore ordered as follows. Defendant Laura Amber Heard's post-trial motion 1 through 4 are denied for the reasons stated on the record. Defendant Amber Laura Heard's post-trial motion 7 is likewise denied for the reasons outlined below. So post-trial motion 1 through 4, on June 24th, Elaine was like, "Hey, Judge Penney, like there's some things that we want to talk about, like the amount that Amber Heard has to pay to Johnny Depp, or what else was there? The amount that Amber Heard has to pay to Johnny Depp, and the fact that the amount is unfair and it was unreasonable, and then that's all I remember. Okay, you guys watch my older videos because we went over it." And then the next one is, the jury investigation for juror number 15. So this is what Judge Penney writes. The purpose of voir dire is to obtain a fair and impartial jury. Voir dire is necessary to ascertain whether any juror has any interest in the case or any bias or prejudice in relation to it, and that he, in fact, stands indifferent in the cause, quotation marks. The summons issued to juror 15 listed his legal name and address. No birth date was noted. Oh, interesting. The court has pulled Juror 15's jury questionnaire, attached as redacted, file under seal. Juror 15 completed the jury questionnaire as himself, filling in the proper birth date. Oh, wow. Okay, so it's filed under seal because you guys remember they are going to seal the jury until, it was supposed to be like until a year after the verdict. So for a year, their information is confidential. The information presented on the jury questionnaire matches information Juror 15 provided to the court. Juror 15 was vetted by the court on the record and met the statutory requirements for service. The parties also questioned the jury panel for a full day and informed the court, and the jury panel was acceptable. Therefore, due process was guaranteed and provided, let me zoom out, to all parties in this litigation. Voir dire. Wait, why is it cut? What? You be cut off over there? Don't be cutting it off. Is it cut off? Okay, it's cut off. I don't know why. I'm sorry. Something is wrong with my Did I resize this? I must have resized it. My bad. Oh, wow. It's like... I don't know why it's like this. Okay. There you go. There you go. That's a little bit better. Corey, you mentioned that dude that didn't brush his teeth for 20 years. It's still haunting me. Would you rather make out with him or would you rather have a prolapse anus? Completely appropriate questions here. Oh, God. That's a pretty bad one. Which one, guys? Which one would you rather do? Okay. Voir dire was conducted in a fair and impartial manner with the court and both parties examining potential jurors. There was no evidence for fraud or wrongdoing. Further, the defendant was provided the jury list 5 days prior to the commencement of the trial and knew of or should have known about any mistakes at any time during the 7-week pendency of the trial. She had every opportunity to object to or to voir dire on the issue. Parties generally must make objections at the time a ruling or order is made to put the court on notice that an issue is meant to be preserved. See, here's what they were trying to do, man. Possibly. Because, like, it was said that they knew that juror 15 had a different birth date and wasn't the same person. But it was like, you know, they wanted to see if the trial was going to go their way. And if the trial doesn't go their way, they're going to be like, oh my God, wait, actually, hold on. There's something wrong here. Like, yeah, let's just mistrial. But yeah, you can't do that. You would have to bring it up a lot earlier. Quotations. Any error in this information shown on such copy of the jury panel shall not be grounds for mistrial or assigned as error on appeal. The parties in the case shall be responsible for verifying the accuracy of such information. Emphasis added. Consequently, defendant as well as plaintiff had an affirmative obligation to ensure the accuracy of information provided for the jury panel. A party cannot wait until receiving, that's what I said, until receiving an adverse verdict to object. For the first time on a known issue since the beginning of trial, the issue has been waived. Even if arguendo, even for the sake of the argument, the objection has not been waived, objections to any alleged discrepancies in the jury list and any legal disabilities of potential jurors must be made in accordance with Virginia Code section That section provides in relevant part, quotation marks, unless objection to such irregularity or disability is pursuant to subsection A herein and is unless it appears that the irregularity was intentional or that the irregularity or disability be such as to probable cause injustice. In a civil case to a party making the objection, then such irregularity or disability shall not be a cause for summoning a new panel or juror or for setting aside a verdict or granting a new trial. Wow!
Lucifer gifted a tier 1 sub to Death Quemo.
Wow! Wait a second. This is actually so cool. Look at how... Did they copy, what the hell is it? What the fuck? What the hell is the screen capturing right now? It ain't screen capturing shit. Why does it look like this? Anyways, the other monitor. This one? This one? Oh. Wait a second. There you go. Look! So cool. Look at how... Wait, you still can't see it? See it. I don't know why you can't see it. There you go. Look at how cool that is. Look. I don't know. Is it always like that? They made your name so big. Thank you, Airbus. Thank you for gifting a sub to Death Quan Mo. I do appreciate it. Thank you so much. All right. Very cool. Wait, what is this doing here? Oh, no, this is a redacted thing. Oh my God, that threw me off for a second. Furthermore, while parties must make this objection while following the above procedure, the party moving under the code section must provide some evidence of prejudice. They did not provide any evidence. Defendant has neither followed the proper procedure or shown evidence of prejudice. A defendant does not allege juror 15th in conclusion on the jury prejudice her in any way. The juror was vetted, sat for the entire jury, deliberated, and reached a verdict. The only evidence before this court is that this juror and all jurors followed their oaths, the court's instructions, and orders. This court is bound by the competent decision of the jury. This order is final. Oh, man. Endorsement of this order by counsel of record for the parties is waived in the discretion of the court pursuant to Supreme Court of Virginia. Damn. Oh, here's the Here's the questionnaire. Yeah, so they filled it out as 1970. So it's not like they were trying to lie, be like, "Oh yeah, I'm born in 1945, yo." IT management. They are U.S. citizen, residing in Virginia for the past 12 months, over 18, legal resident of Fairfax County. They can communicate in English. Yeah, because this one right here, I am 70 years of age or older, do not wish to serve. So if they were indeed pretending to be a 70-year-old, they would have check at that box right there. Man, what a mess, but it's pretty funny. Man. Elaine, this order is final. Yeah, because Elaine tried to bring it up on June 24th. She was like, judge, there's some things I want to address. And then the judge is like, no. And she's like, well, can I at least put in the post-trial motion? Okay, fine. Go ahead and put in the post-trial motion. But, okay. Alrighty then. Well, anyways, maybe things will go quiet. Actually, I don't think things are going to be quiet for the next couple of weeks, but we'll see. All right, guys, that's it. Just a quick little update of what's going on in the courts. And yeah, how are you guys doing today?